Welcome to the Wisconsin Employer Lawyer Hotspot, connecting you with legal information and explanations to some of the difficult but common concepts of labor and employment law. I'm Jesse Dill, a Wisconsin labor and employment attorney. My goal is always to keep you informed about the latest and most relevant topics in labor and employment law. Be sure to look for other Wisconsin Employer Lawyer Hotspots and the Wisconsin Employer Lawyer blog at www.wiemployerlawyer.com. And follow me on Twitter through the handle @Jesse_Dill. Today we'll be looking at non-compete agreements in the workplace. Non-compete agreements may be a very valuable tool to help protect your business. Creating an enforceable agreement, however, is no easy task. We'll talk about some of the basics so you know whether a non-compete agreement is right for any of your employees. So what exactly are non-compete agreements? In the most simplest terms, a non-compete agreement is a means to protect an employer's business interests. It's an agreement between an employer and an employee that the employee will not go to work for a competitor of the company immediately after the employment relationship ends. Non-compete agreements aim to protect an employer's investment in an employee who has special relationships with customers or clients of the company, or has access to special information of the business as part of their employment. A great example of where non-compete agreements often apply is with a salesperson for a company. Salespeople often have special relationships with customers or clients that account for millions of dollars of business of the company. Allowing those employees to immediately go to work for a competitor does not require the second employer to make the same investment in the employee as the first employer. It puts that first employer at a competitive disadvantage, which a non-compete agreement seeks to address. Non-compete agreements are one of several restrictive covenants that might be put into place as part of employment. Other restrictive covenants include non-solicitation agreements and non-disclosure agreements. Non-solicitation agreements are where an employee agrees not to solicit or attempt to attract away from the employer and other employees of the employer. Non-disclosure agreements seek to identify confidential information and prevent an employee from disclosing that confidential information to outside individuals during the course of their employment or for as long as that information remains confidential after employment ends. Non-compete agreements might be included as part of an initial employment agreement or also implemented as part of a separate agreement altogether with the employee. However, an agreement that is realized after the employment relationship ends in Wisconsin will need to be supported by consideration. Often this will be something like a financial incentive that is provided to the employee to sign the agreement. If an employer believes that a non-compete agreement is right for certain positions in its workplace, there are 5 requirements to keep in mind when putting together such an agreement. These requirements come from the Wisconsin Statute on Non-Compete Agreements, Section 103.465, and also various court decisions that have been handed down over the years. The first requirement is that any time restriction contained in the non-compete agreement must be reasonable. This refers to the period of time in which an employee is not allowed to compete with its former employer. At most, this is probably going to be up to a period of 2 years. However, courts evaluating the reasonableness of restrictions in a non-compete agreement such as time are going to look at factors such as the occupation of the employee and how long they were in that position to determine whether the period of time is reasonable. What might be reasonable for one occupation is not necessarily going to be reasonable for another. The second requirement is that the geographic restrictions within the non-compete agreement must be reasonable. That is, the area in which the employee actually serviced, is probably going to be the only restricted area that a court will approve of in the non-compete agreement. For example, if an employee exclusively sold to customers in the Milwaukee-Kenosha Racine area, it's probably going to be unreasonable to restrict them from competing in a position that services Marathon, Taylor, and other northern counties in Wisconsin. However, if an employee serviced customers or clients throughout Wisconsin, then a statewide restriction might be reasonable. Again, these evaluations are fact intensive and are going to come down to the specific position at issue. The third requirement of non-compete agreements is that they must be addressing a legitimate employer interest. Typically, this is going to be customer-client relationships or special information that the employer relies on to conduct its business and that it wishes to maintain confidential to its workplace. Fourth, the restrictions cannot be unreasonable for an employee. Courts want to see that employees will be able to gain other employment despite the restrictions in the agreement. Fifth and finally, the agreement cannot be contrary to public policy. This typically gets at situations where the community around the employer and employee would be harmed but if the restrictions were fully enforced. For example, if there's a physician who's the only cancer treating physician within the area of restriction, and that would harm other individuals of the public from seeing anyone to treat their illness, that might be cause for a court to hold a non-compete agreement unenforceable. Employers who want to put non-compete agreements in their workplace need to keep in mind a few things with respect to creating these agreements. More than anything, this is not something that employers should be trying on their own. Employers really need the assistance of counsel well versed in this area of the law to come up with an agreement that both meets the needs of the employer and also is something that can be enforced in court down the road if necessary. Any agreement that you ask employees to sign also needs to be tailored to their position. Employers should not be attempting to put into place a general agreement that applies to any and all employees. You need to look at the job, duties, and responsibilities of the employee and come up with restrictions that meet the aspects of that employment position. Also, employers need to keep in mind that state particular rules apply to non-compete agreements. States often have various differences in this area of law compared to neighboring states. What you might have heard of that works in one state will not necessarily work in Wisconsin. For example, Illinois treats continuing employment as sufficient consideration to support a non-compete agreement that is entered into after the employment relationship begins. This means that if the employee signs the agreement after beginning employment and continues to work for a certain period of time, that situation alone might be sufficient to hold the employee accountable to the agreement. In Wisconsin, that is not something that a court will accept as sufficient to support the agreement. Moreover, this area of law is quick to change. It seems that every few years a new decision comes down that changes the way that employment law attorneys need to approach these agreements. Finally, employers should keep in mind the old adage that less is more. Although you may not want an employee to do anything that could harm your business interests, a conservative non-compete agreement may be much more likely to be upheld in court and enforceable and protect your interests. Once a non-compete agreement is in place, the next concern for an employer may be enforcing that agreement. One thing to keep in mind about enforcing these agreements is that the process moves very quickly. Within days or even hours, an employer might find itself in court seeking a temporary restraining order and permanent injunction enforcing the agreement between the employer and the employee. Employers should also keep in mind that non-compete agreements that need to be enforced in court are considered prima facie suspect. This means that any in court interpreting one of these agreements is going to look at them with a suspicious eye and err on the side of not enforcing one of these agreements over enforcing one. Additionally, employers might be familiar with the term blue penciling non-compete agreements. In some states, courts are granted the authority to rewrite any terms that they find unreasonable to make them reasonable. Wisconsin is not a blue pencil state. However, in a recent court opinion, the Wisconsin Supreme Court determined that courts might strike terms of a non-compete agreement out altogether to make a non-compete agreement enforceable. However, they still do not have the authority to actually rewrite the terms of a non-compete agreement. Thanks for listening, and I hope you found this presentation helpful. Look for other Wisconsin Employer Lawyer hotspot topics on the Wisconsin Employer Lawyer website. And a reminder, you can also find important updates on the Wisconsin Employer Lawyer blog or by following me on Twitter through the handle @Jesse_Dill.